Good evening. I'm Serena Oberstein, Executive Director of Jewish World Watch. Rooted in our own experiences of persecution, Jewish tradition, and values, we were founded in 2004 when the silence about the genocide in Darfur was deafening. 16 years later, genocide and mass atrocity are still rampant, but we are not helpless in this fight. Jewish World Watch compels and enables people to stand up and take action through advocacy, education, and direct aid to combat mass atrocity worldwide. I want to welcome and thank you for joining us this evening for Restitution and Reparations, a conversation examining the role of reconciliation, restitution, and compensation for the losses suffered by genocide victims and survivors. Today's conversation is part of Impact in Action, a month of events focused on raising our collective voice to fight genocide. It is being produced in partnership with the Center for the Study of Law and Genocide at LMU Loyola Law School, USC Shoah Foundation, and UCLA's Promise Institute to discuss the importance of preserving survivor testimony, rebuilding livelihoods, and reconciliation. I want to thank our illustrious panelists, Rajika Shah, the Deputy Director of the Center for the Study of Law and Genocide at LMU Loyola Law School, Sherry Regg, the Director of Policy Affairs for the Conference on Jewish Material Claims Against Germany, Pamela Villasenor, Director and Executive Advisor of the San Bernardino Tataviam Band of Mission Indians, and our moderator, Stanley Goldman, who will say more about in a moment. I also want to thank our Global Vision sponsors, Lawrence and Jane Z. Cohen and the Goldrich Foundation. We hope you'll join us for more events throughout the month of Impact in Action, and then we hope that you'll be compelled to take action. Our dynamic moderator, Stanley Goldman, is a professor of law at Loyola Law School in Los Angeles and the founding director of the Loyola Center for the Study of Law and Genocide. While attending Loyola Law School, Stan was executive editor of the Loyola of Los Angeles Law Review. Goldman joined the Loyola faculty after serving 8 years as a Los Angeles County public defender. His scholarship is principally in the area of criminal procedure, evidence, and genocide studies. He's been a bar review lecturer in ethics, criminal law, criminal procedure, evidence, trusts and wills, and constitutional law. He co-anchored a national program on CBS Network Radio and has spent over 2 years as a regular contributor on CNN, NBC. Goldman has spent more than 10 years with the Fox News Channel as the network's on-air legal editor, as a news correspondent, analyst, and occasional host. Stan authored Left to the Mercy of a Rude Stream, The Bargain That Brokered Adolf Hitler and Saved My Mother, a book about his own mother, Malka's release from the Nazi concentration camp, Ravensbrück. We are truly honored to have him guide us through this conversation today. In a moment, you'll hear directly from Stan, but first, I want to welcome Rudy Ortega Jr. Rudy is the elected tribal president of the Fernandino Tataviam Band of Mission Indians. In addition to advocating on behalf of his own tribal community, President Ortega serves on the Los Angeles City County Native American Indian Commission and was appointed by the governor to the Santa Monica Mountain Conservancy. We welcome him to give an invocation before we start the evening's program.
Hello, Haminatam Netano Rudy Ortega Jr. I'm honored to be here today, this evening, to give the opening blessing and welcome. The song I'm going to sing, the words are Paco, which is inter, Kema means come. Usually we sing these songs when we welcome people into our village traditionally. Or today we sing their songs when we welcome people to a gathering, to an event such as this. And so what it does is essentially bring in good will, good strength, and good mind as we come to this discussions today, this evening. So I'd like to do that, sing this traditional song for you all. Paco que ma'a, Paco que ma'a, Paco que ma'a, mena que ma'a, mena que ma'a, Paco que ma'a, Paco que ma'a, Paco que ma'a, mena que ma'a, mena que ma'a, Paco que ma'a, Paco que ma'a, Paco que ma'a, mena que ma'a, mena que ma'a, Paco que ma'a, Paco que ma'a, Paco que ma'a, mena que ma'a, mena que ma'a, Paco que ma'a, Paco que ma'a, Paco you. Again, just it's a pleasure to be here. My name is Rudy Ortega Jr. I'm the president of the Fernandino Tatavian Band of Mission Indians. We are Mission Indians from Mission San Fernando. We are descendants of 26 villages that encompass San Fernando, Simi, Santa Cruz, and Antelope Valleys. So I encourage you to learn more about our people. Visit our website, tatavium-nsn.us, so you can get to know who we are as people and our legacy and our history here throughout Los Angeles County. So thank you for having me this evening.
Thank you so much, Rudy. And before Stan gets started, just as a matter of housekeeping, if you have any questions throughout the panel tonight, please use the Q&A function, and it'll come directly to us so that we can look at them as they're coming in. Thank you again.
I think that means the ball's been tossed to me. I'd like to, just simply introduce Rajika, if I could. Rajika and I work together at Loyola, and she's going to be talking, I think, in part, at least I hope she mentions, a friend of the court brief we have just filed on behalf of the Loyola Center for the Study of Law and Genocide, which we work with. That's our organization. And we filed it in the US Supreme Court because there's a pending case there on Holocaust reparations and jurisdiction, actually 2 separate cases. I just wanted you to know that although there are the names of several lawyers on it, myself included, Rajika wrote it. And we just basically kibitzed, making minor editorial suggestions. So she is the author of that. She's quite an accomplished scholar in this area. And I just want to toss the ball to her. Rajika?
Thank you so much, Stan. And thank you to Jewish World Watch and to Serena for inviting us to participate in this series. So I will go ahead and just dive right in. So I want to set the stage a little bit for this discussion on reparations and restitution. The 2 previous panels in this series focused on securing testimony and legal mechanisms for accountability. These are, of course, necessary steps in the process of grappling with the immense needs and challenges of rebuilding torn communities after genocide or other mass atrocities. Really, it's the process of transitional justice that we're talking about. So what role do reparations and restitutions play? What does that mean, really? The question of reparations, and specifically restitution or compensation, really plays a vital role in the transitional justice process. Without the recognition and redress specifically for the losses that are suffered in a genocide, the aspiration for reconciliation that allows survivor groups to not just acknowledge the past, but really try to move forward from it and transcend it, which can help to transform that loss and pain and anger into new growth. Without all of those vital components, that change can really remain very slow or even elusive. And so for many, reparative justice is both a legal and a moral imperative. So when we say reparations or restitution, what are we talking about? I want to frame this conversation in terms of the international law of reparations, which requires states to make full amends to one who suffered a legal injury due to the state's internationally wrongful acts. I know that probably sounds a little bit abstract to you. So reparations really is a very broad category, and it, as it says, really full amends. There are several components to that, one of which is restitution. And of course, going along with restitution, compensation, where restitution is not available. These are really core forms of reparations. Other forms include apology, satisfaction, There are several categories. But here in this talk and on this panel, I really want to focus on restitution and compensation. So in the context of genocide, what does that mean? Of course, victims and survivors of a genocide or mass atrocities, they indisputably have individual claims for personal injuries for themselves and for the loss of the lives of their loved ones. But increasingly, particularly after World War II and the Holocaust, and largely, in fact, as a result of the success of sustained Holocaust restitution efforts over the last 75 to 80 years, international and domestic law have increasingly required restitution for the victims of mass atrocities. So compensation for injuries and restitution of property taken or lost or destroyed during a genocide, these are both now considered to be vital components of transitional justice. So you have restitution as a legal requirement being increasingly the norm, and perhaps even more crucially, is what this does for victims and survivors, which is it really provides a sense that their losses and their suffering really matter. So again, this, I will talk just a little bit about some specific property restitution cases, indeed the two cases that Professor Goldman mentioned that are now currently at the Supreme Court and in which we filed an amicus brief just less than a month ago. So what is property restitution after a genocide? What does that mean? What does it look like? Property losses can cover a really wide range of categories that can include real property, livestock and other agricultural assets, insurance claims, bank deposits, looted assets, artwork and other cultural objects, household goods. There's really a very wide range of potential claims. So let me just talk briefly about the cases pending before the US Supreme Court. There are two cases currently on the court's docket in this term, Simon v. Hungary and Philip v. Germany. At issue in these cases, one of the core issues is the explicit holding by a lower appellate court that property takings themselves, apart from any of the killings or murders that take place in a genocide, the property takings themselves constitute a form of genocide. So as Professor Goldman mentioned, the center has just filed an amicus brief on this issue in both of these cases. We were very ably supported by our excellent students in our Loyola Genocide Justice Clinic, both previous and current students. And for anybody who's interested, you can follow this case. The oral argument is scheduled for December 7 and a ruling is expected sometime next spring. So what are these cases? Let's talk a little bit about Simon v. Hungary. Just briefly, the plaintiffs were 14 Holocaust survivors originally from Hungary, and they sued on behalf of a class. So it's a class action. The defendants were the Republic of Hungary itself and a state-owned Hungarian railway. And the claims relate to the Hungarian collaboration with the Nazis in the later stages of World War II to perpetuate the deportation and extermination of nearly 500,000 Hungarian Jews. So the plaintiffs there brought claims for property loss as well as other claims. The other case, Philip v. Germany, there the plaintiffs were descendants of Jewish art dealers, a consortium of Jewish art dealers in Germany before the war. The defendants were the Federal Republic of Germany itself, as well as a German governmental cultural institution. And there the claims related to the forced sale under duress in 1935 of a collection of medieval relics and devotional art known as the Weltschatz. This collection of art was sold under duress at barely 35% of its market value, at the behest of Hermann Göring, who wanted to present this collection to Adolf Hitler as a gift. So what is the precise issue here? Just very, very briefly, because the defendants in these cases are both foreign sovereigns, jurisdiction in US courts is governed exclusively by federal legislation known as the Foreign Sovereign Immunities Act. Normally, a foreign sovereign is immune from suit in US courts. But under this act, there are a few exceptions to that immunity. And there is one exception at issue in these cases known as the takings exception. Under this takings exception, a foreign sovereign can be sued in the US if rights in property taken in violation of international law are at issue. So in these cases, clearly genocide violates international law. The question for the courts was, do the alleged property takings bear a sufficient connection to genocide that they amount to takings in violation of international law? The answer in both cases was yes. In Simon, this is the lower appellate court that we're talking about now, the DC Circuit Court. In Simon, the court held that the property taken from Hungarian Jews was integral to this governmental policy and plan to destroy Hungarian Jewry and really their entire way of life. And in Philip, the court held that the forced sale of this Weltschatz art collection occurred in this environment of persecution and economic duress. The Holocaust was already well underway, and the Nazis really drove Jews out of their ability to make a living and thereby survive as a group. So that is the issue that is now currently pending before the US Supreme Court. And we'll see what they say. To be determined.
All right, thank you, Rajika. Yes, to be determined, and it will probably set the standard for at least foreign attempts to retrieve and use American courts as jurisdiction involving various foreign crimes against humanity. So they're big cases for the US Supreme Court to settle. Sherry, I think it's your turn. You're going to be talking, I think, about something which I'll explain later is kind of personal to me, which we'll talk about later, and that deals with lawsuits that have actually been filed in the United States and had been settled by courts in the United States without actually ever determining that there was actual jurisdiction. But settlements were reached before that phase of the cases ever began. Sherry, you want to just start in?
Yes, thank you so much, and really thank you for including me on this panel. I'm really honored to be here. So picking up where Rajika left off, I am coming to this with a different hat. I currently am at the Conference on Jewish Material Claims Against Germany, which actually sort of began the entire restitution process back in 1951, 1952. But for 20 years before that, I was the Deputy Special Master in the Swiss Bank's Holocaust Settlement, which was settled before Judge Edward R. Corman in the Eastern District, and working very closely with him and with Special Master Judah Gribitz. This case arose from claims involving Switzerland. So again, it's an interesting tie-in that we're talking not so much about Germany, but about other European countries. lawsuits were filed in the late 1990s, class action lawsuits again, against Switzerland, alleging that Swiss financial institutions collaborated with and aided the Nazi regime by knowingly retaining and concealing assets of Holocaust victims, and by accepting and laundering illegally obtained Nazi loot and profits of slave labor. So there were already a variety of claims for assets, for looting, and for slave labor. The background to these claims, though, was decades in the making. Switzerland was ostensibly a neutral nation during the war and held itself out as a financial haven, and many Europeans, and particularly Jews, sought to deposit their assets in Swiss banks seeking protection. After the war, they came looking for their assets and they were turned away. They were told that the banks did not have the accounts, or had they had them, there were no more records, or they had been eaten away by fees, or the banks couldn't talk to the claimant because they didn't have a death certificate. Obviously the concentration camps did not give out death certificates. And periodically the banks would conduct surveys of their accounts, and they showed a few hundred, a few thousand, very minimal, and repeatedly said that they did not have these assets. In the late 1990s, once again, the survivors and their heirs, it was often largely heirs, once again sought redress. And this time they succeeded. And that was because of the US court system. And it is the US judicial system that helped bring about a $1.25 billion settlement of a variety of claims. Because it's a class action, I'm going to go through it very quickly. There needed to be notice and an opportunity to be heard, because when you're closing out claims, you need to make sure that the potential plaintiffs are given a chance to speak up or to opt out. In this case, only a few hundred opted out. There were worldwide notices. There was a lot of media coverage. The very unique aspect was that potential class members were asked to fill out what was called an initial questionnaire, a survey of what really it was sort of a chance to tell their stories preliminarily, to get a sense about what different people would be saying happened. And it turned out that 600,000 were returned, 600,000 Holocaust victims and heirs, which is sort of the largest survey of certainly a Jewish population ever conducted, many people have considered. So the settlement was for all of Switzerland, although the main charges were really against the banks, but the Swiss government did not play a formal role, but the banks, probably acting in consultation with the government and with other Swiss entities, settled on behalf of the entire nation. And the parties created, and I say parties because I and Special Master Gribbets, we were not yet involved at this stage. We came in after the settlement agreement was reached, and what they agreed to was a group of 5 classes and 5 victim or target groups. So the classes were for bank accounts, for 2 slave labor classes, for refugees, and for looted assets. And then there were 5 different victim groups, although obviously the case was brought largely on behalf of Jewish account owners. It was agreed that other groups were also victimized and should be included, and therefore it included Romani, which is sometimes more often known as gypsies, but Romani, Jehovah's Witness, homosexual, and disabled class members. So we were presented with sort of a box that we had to work within. We had the classes, and we had the different groups, and we had US law. And the question was, where do you go from here? And although the parties could barely agree on anything, one thing that they did agree upon was that there should be a special master, somebody to help the court in devising the program, devising a recommendation, and then following through. And they agreed unanimously that the person to do that was Judah Gribbets, who I've had the honor of working with for 20 years in my prior life on this case. And he had vast background in governmental affairs and politics. He's an attorney. He's a Jewish scholar. He was one of the founders of the Museum of Jewish Heritage. So he really knew the lay of the land. And fortunately, I was working with him and was able, to become involved in the case. So what did all of this bring about? Well, the settlement was for $1.25 billion, but because of tax advantages and interest, although interest rates were quite low over the last 2 decades, we actually were able to distribute more than that amount, $1.3 billion nearly, to over 458,000 Holocaust victims and heirs in over 80 nations. And of that amount, the majority was allocated and then distributed to those who had bank accounts. And we were not operating in a vacuum. A lot of some of the good that came out of the litigation of the 90s was that it caused many Europeans to conduct sort of a self-examination of their role. And Switzerland had its own experts and historians called the Berger Commission, but also critically involved was Paul Volcker, who was the former head of the Federal Reserve in the US, and he led a team of auditors. And what happened was that although over all those decades, the banks had said that there were only a few hundred accounts, Mr. Volcker, maybe to the bank's surprise, found that there were actually 36,000 accounts that probably or possibly belonged to Nazi victims that were in Switzerland from 1933 to 1946. However, what he also found was that although there were about 7 million of those accounts, the banks had destroyed the records for a third of them. And yet the records, or partial records for 2/3, did remain. And so he also found, and the Berger Commission bore this out, and Judge Corman has written extensively, that the banks engaged in inappropriate activities. They turned accounts over when, as Rajika had mentioned earlier, for those who were under duress, and when the Nazis came asking, the banks cooperated in turning over the accounts. Sometimes they compiled lists proactively. In other cases, although they kept the accounts, they charged fees against them over the decades so that the balances were down to minimal or zero. And they destroyed documents. And because we were operating within the confines of the US class action system, the dictate and the appropriate thing to do, and Judge Corman strongly agreed, was we needed to prioritize the claims. And the bank account claims, Rajika has given you some information about how there's still some uncertainty. Even today, the litigation is continuing about what kind of Holocaust claims really can be sustained in a US court and what cannot. And Judge Corman has written extensively and has said that if the case had been tried, it's not clear that the non-bank claims actually would have been sustainable. But the bank claims were fairly straightforward. They were simple breach of contract, their fiduciary duty. You put your money in a bank, you're supposed to get it back. So we put the priority of the claims process on the bank account claims, and we had to set up overseas in Switzerland because the bank records were not allowed to leave the country because of banking secrecy. But we set up an elaborate, at its height, 100-person process that reviewed the claims and administered, and I was almost said adjudicated, but we did not adjudicate, we reviewed, because we tried very hard to make it as straightforward and as simple as possible for claimants, although it was a complex process. And if you, there's a lot more information on our website, which is being sustained now by the Holocaust Museum. It's www.swissbankclaims.com. But to give you just a couple of examples, I'm sure many of you are very familiar with the case of The Woman in Gold. The movie was made recently. And here are 2 photos. One is Maria Altman, who her family, her aunt was the woman in the painting, and after a long fought battle was able to get her painting back. But not so well known is that before the family was able to finally get back their painting, they got back their Swiss bank account from us. The family had set up a very elaborate agreement protecting their assets in Switzerland, which was breached by the banks immediately right after the Holocaust. And so that was a $21 million award. Now our average bank account award was $184,000, but we tried as best as we could to assess the records, and where the records showed the value, that was what was awarded. But right next to Mrs. Altman is Elizabeth Dennis and her little girl. And, you know, this is another example of a bank account of a less well-known, less well-off family who, you know, entrusted their assets to a Swiss bank. They were killed in Auschwitz. And after the war, the family was asking, and the banks deflected, and the bank said, come back to us, we'll tell you when we're ready to communicate with you. And then the family was told that the records were gone. And yet we had the records. So obviously the records were not gone. So these are two of thousands upon thousands of the bank account awards that we were able to issue. Now, just briefly, because I know time is short, and I did mention this was complex, there were other claims and other processes. There were slave labor claims, and that was for people who were, and you're seeing a picture of slave labor at Auschwitz, at the Krupp camp. And I know that this is something that's going to be talked about later by Stan, but this was actually Krupp company having slaves. Now, every German entity use slave labor. I mean, German historians have spent decades researching that, and that's loud and clear. The issue was whether there was a connection to Switzerland, and it turned out that there indeed was. We were able to get what's called the 1945 frozen assets list, which when Switzerland knew that the Allies were winning in 1945 and they were asked to freeze their bank accounts, and they finally did so. That list shows that virtually every German governmental, financial, business entity had a Swiss bank account. And so therefore we were able to both historically accurate and legally accurate make the connection that everyone who survived a camp or a ghetto had to have conducted slave labor, or they would not have lived. And every one of those people, somehow their assets were transacted through Switzerland, because every place that they worked had a bank account in Switzerland. And so that enabled us to create a process that rode the coattails of a separate slave labor claim against Germany that was being litigated at the same time and settled outside of the US courts. It actually settled as an intergovernmental agreement with the US State Department's help. And that was a 5 billion euro slave labor program. And we worked in tandem with it to make sure that claimants had a more simplified application process. And therefore, whenever they got a slave labor payment from one, they would get one from us. And sometimes we would issue a payment even where the German program did not. There was also an unusual fact, which again, the historical analysis helped bring this out. The Swiss side insisted upon including two further claims. One was for something called slave labor 2, which was actually for companies, for Swiss companies that had subsidiaries or other departments in Germany that used slave labor. And a little known fact that there were Swiss companies using slave labor, and some of them I'm sure you've heard of, like Nestle, and others were far less well known. That was very complicated. I can't get into all the details, but that was the one class that was not limited to the 5 victim or target groups, which meant it almost could have opened the settlement to hundreds of thousands, if not more, claimants. That was a problem, and there was a lot of litigation to follow to narrow the scope. And the next class is the refugee class. Now, obviously, we spend a lot of time today thinking and concerned about refugees, and I'm sure many of you are aware that no country in the world had a great record when it came to taking in refugees from Nazi Germany. The US is on that list. Switzerland had, in some respects, a decent record. It did admit tens of thousands of refugees, but it also expelled many refugees, and it closed the doors to them. What you're looking at is an example of a passport with a stamp of the letter J for Jewish. That was Switzerland's idea. Switzerland advised Germany, or requested that Germany make sure that all passports of Jewish citizens had a J stamp, which, as you can imagine, made it not only difficult, if not, often impossible to seek refuge in Switzerland, but in any other country because of that large glaring J. Those who were allowed in were often mistreated. There were family separations then, again, something that is very much in many of our minds. And so that was yet another category of claimant that we compensated, that again, the Swiss insisted be part of the settlement, because although it was not necessarily clear whether a claim against Switzerland could have been sustained in a US court, there were some proceedings in Switzerland involving refugees. And so that part of the settlement was to, again, give an all Swiss release, covering any claim that could have arisen out of wartime activities. The last and final class was for looting, and I mentioned that, and here are some two of the recipients. Now, this class was vast because everybody was looted. There's not a Nazi victim who was not looted, whether formally, at the railway station, or stripped of everything in the camp or the ghetto, or fleeing and leaving behind what they had. And it's not clear whether it ended up with the Nazis or whether the next door neighbor got it. It was rampant. It was, the greatest theft in history. And the issue was, what connection was there to Switzerland? Now, many of the assets probably did end up in Switzerland or were transacted through, but there was really no way to prove it. And so therefore, US law allows something called a cypre remedy, the next best thing. And so you can compensate those who are most in need. And therefore, we concluded, and Judge Corman heartily agreed, that those who were neediest should get humanitarian aid in the form of food, medical packages, sometimes in the case of the Romani victims, a side of beef literally shipped into the farthest reaches of Europe. And this was a tough part of the case, because there were some battles over who is the neediest and where they are. And those are not pleasant conversations to have, and there was litigation. But
Sherry, we're gonna have to move on. I really do hate to cut you off, because this is fascinating stuff. I want to make sure we have enough time for Pamela. I apologize. Pamela Villasenor is as you've already learned, a representative of a Native American nation, and I will say, having studied in some degree the issue of genocide over the last dozen years, I can't imagine there is any genocide scholar in the country who would not agree that genocide was perpetrated against Native American nations by the United States government. And it's odd that we don't have as much formal litigation in the past about this very American issue as we do about some other issues from around the world. So please, Pamela, please start us out talking about this.
Thank you, Stan. My name is Pamela Villasenor, and my American, I say that because it's less than 80%.
I think we're having just a little trouble hearing you. It's breaking up again. Is there your sound's breaking up just a little bit, or at least for me it is. I don't know if anybody else is having trouble. Yes, but there's breaks in your voice. I think maybe we can reset. In the meantime, I want to remind people that if you have any questions that you'd like us to ask, please use the Q&A, and when we have time, hopefully at the end of the discussion, we will maybe be able to get to a few of the questions.
Can you hear me?
That was a little better. Let's give it a try.
My name is Pamela Villasenor, and I really am American. 80% of California Indians did not survive the American Gold Rush. This means that only 20% survived that era, and I am the descendant of that 20%. And so today we're talking about how to address previous harm and bring about balance. And for Indigenous peoples, that type of restorative justice is often part of our worldview. So I'm going to talk about some historical context, lessons learned from a previous court case, and the state of current reconciliation for California Indians. And when I say California Indians, I'm referring to those of us who are from villages and tribes that existed in these lands before, exist today, and will exist tomorrow in what we refer to as California. In terms of the historic relationship with the United States, it's difficult to discuss the status of California tribal peoples without having some understanding of the past 2 centuries of historical trauma that has impacted our lives. So I wanted to take a glimpse into the 1850s and that early years of statehood for California. California was founded in September of 1850s, and the newly formed state legislature and Congress members worked very quickly. They passed an act for the government and protection of Indians that legalized slavery. The US military provided guns and ammunition to white American militias. There was the widespread taking of village lands with very little recourse that I'll expand later. There's the impact on health. So the taking and restriction of land, of course, leads to a loss of food sovereignty or the purposeful creation of dependence on the US. There are the pandemics as a result of the incursion of American and European settlers. And finally, there is the state-sponsored California Indian genocide, where it's estimated that between 1846 to 1873, the US spent $1.7 million in federal and state appropriations and campaigns against California Indians. And despite the slate of eradication policies, our tribal people survived. They had agency, they had resilience, and they were using legal avenues in the US courts. So the story of California Indians is really one of survival, resilience, and inspiration. So now that I've painted the picture for you, I wanted to get to lessons learned. Moving beyond historical context, there were 18 treaties in California between 1851 and 1852, which all went into a secret session of US Senate, and they refused to ratify them. In fact, they created a secrecy injunction on those treaties that didn't really come to light until 50 years later. And when they did, it was an aha moment for everyone outside of Indian affairs. The fact that the treaties existed, that there had been an injunction of secrecy, and that it had not been rescinded since that time in the early 1850s. And so what happened was this all leads to a jurisdictional act that grants the California Attorney General to bring suit in the Court of Claims for California Indians, specifically for the illegal extinguishment of Aboriginal land title and right to occupancy, but very clearly not for the California Indian genocide. So it's not until the 1920s that a settlement is even provided for California Indians, but it's highly problematic. One, there's the creation of judgment rules that is necessary in order for government agents to decide who is a valid claimant. But it's obvious that they really didn't understand California tribal people, and we make that assumption because there were a number of errors and misunderstandings in the paperwork. Number two, it gave cash disbursements to individual California Indians, not tribes. And this is highly problematic because the impact is the erosion of tribal sovereignty, because it very clearly undermines a collective-based people and instead upholds this individualistic values that are part of US capitalism. And of course, land is not on the table as part of that settlement, which of course Indigenous people would have advocated for. And the money that's given in the settlement is not that much. My mother received $700 in the 1970s roll, and this was meant to pay for the illegal extinguishment of Aboriginal land title for the northern half of Los Angeles County, for which my people's villages are from. So all this to say, the California Jurisdictional Act and subsequent California rules leave us with at least a blueprint of what worked and what didn't work. In terms of current reconciliation and acknowledgement, that's where California Indians are right now. In 2019, California Governor Newsom officially acknowledged the California Indian genocide. And included in that acknowledgement was a promise to create this new council called the Truth and Healing Council. It would be a 12-person council comprised of tribal peoples from throughout tribal nations in California, and they have 4 years to develop a report with findings. There was an executive order issued along with this formal apology, and it was just this year in October that the deadline passed for California tribal people to be nominated to this council. So we are hoping that the governor's office is leafing through all of those recommendations to put together a council, which means that for California tribal nations, we are in the very beginning stages of reconciliation and restitution. for the state-sponsored California Indian genocide. And while there is traction for reconciliation, there is a long road ahead to honor the 20% and those of us who descend from those survivors. And just as a closing, as we talk about bringing back this type of restorative justice and undoing harm and trying to prevent future harm, I think it's really important that we ask who are those claimants, what we can do to go forward, and what are the type of mechanisms that are being afforded to survivors in the international arena that the United States is not affording to the indigenous peoples here in the United States. Thank you.
All right, thank you, Pamela. I know that I'm. Let me just. I know I was asked by Serena to talk just a tiny bit about the fact that I too once received, actually twice, a reparations check, and that was out of the Swiss banking cases. My mother had I filed on her behalf. She had been in slave labor. She was not in slave labor in Auschwitz. She was standing in line one day, waiting to be executed, quite literally. And the line was cut off just in front of her, and she was put on a train along with 500 other women, 499 other women. And they rode for 3 days and 3 nights on this train, not knowing where they were going. And 3 days later, when the doors opened, they found themselves in the heart of Berlin, of all places, at a factory run by the Krupp family that had specifically asked for non-Jewish women who were in Auschwitz to be delivered as workers, but somehow the message got somewhat garbled in transmission, and instead the Germans had sent 500 Jewish women. So the factory found itself suddenly with something it really hadn't wanted, which were 500 Jewish women, and those 500 Jewish women found that they were still alive, to their surprise. So my mother had, we'd filed, at the time there were slave labor and Swiss banking cases. My mother did not have a Swiss banking account. She actually eventually a check was issued for my mother, and as part of the slave labor component of that case, by the way, not $180,000, it was $1,500. But it meant a lot to my mother, and if I might, it occurred to me perhaps there are just 2 quick paragraphs I could read out of a book I wrote about it, which Serena had mentioned, and that was in front of Judge Corman. The slave labor cases, the Swiss banking cases, it was especially in the slave labor cases, I should designate, you had to still be alive in order to collect. If you died before a certain date, you were unable to collect. And if memory serves me, February 15th, 1999 was the date eventually selected. If you died before then, you couldn't collect, neither could your heirs. If you lived past that, you were in the class that could potentially collect. And the plaintiff's lawyers were not crazy about that idea that the dead would never receive justice from this. But as I say in the book, their willingness to settle was not motivated, the plaintiffs was not motivated not only by the realistic possibility that they might lose a yet to be ruled upon motion to prevent them from suing this in American courts, but also by 1999, a significant number of the senior citizen plaintiffs were dying each day that the negotiations proceeded. And so a settlement was reached. And as I say, my mother anxiously awaited payment for which, by dint of tenacity in both her initial survival and her subsequent longevity, she had applied and qualified. It wasn't that she was in desperate need of the funds, as was unfortunately true in the case of many survivors. It was just that she'd always felt making the Germans pay for anything was something of a small victory over the nation that she had never quite forgiven. the check was mailed to her, but by the time it arrived, she was no longer there to receive it. She'd passed away between the time the check was mailed and the time it arrived at our apartment. And therefore I, as her only heir, received the right to deposit the checks that received 2 of them in succession. So some of this has significantly to do with needing funds, as many survivors did, especially the older ones, obviously, and many of them were already quite old, but some were very old. But even if they didn't need the funds, the recognition and the getting payment from the country that had so wounded her was a significant motivating factor. In fact, my mother also received and had for some time monthly small checks from the German government as reparations. And I don't think it was a coincidence that the day after we received one of those monthly checks, which my mother kept asking me about whether it arrived yet or not. It was a couple of days late. And so she kept asking me, and it arrived on a Saturday, and I took it in and I deposited it in her account in the bank, and she passed away Sunday morning. And I don't think it was entirely coincidental that she had lived on long enough to have collected that last check. For her, it was a matter of personal will to get what she could. In fact, she once said to me, when I thought she was very ill and dying, it turned out she lived about another 18 months. She said to me quite literally, and I'll use my mother's accent, which is actually the way she sounded, "Stanley, don't worry. I'm not going to let those German off the hook. They got to keep sending me my checks." And she lived another 18 months to collect those checks. So there's a lot of emotional value as well as financial issues tied in with the idea of acknowledgement and the payment of even small amounts of reparations. All right, I'm wondering if we have questions. Pamela, let me ask you: is there any court case right now involving potential reparations, potential restitution for, let's say, the land in Los Angeles or any other part of the land taken by the government?
I know that my tribe is a federal process of federal acknowledgement, so the trust relationship, but that's different from genocide. That's through tribal sovereignty. But I would mention that the very process of forcing tribes to go through this is probably an act of genocide itself.
Of forcing them to actually have to litigate this in the courts? Is that what you're talking about?
It's actually pre-litigation. So it's through the United States courts. If the United States decides that it does not want to uphold the trust responsibility with our tribe, then it goes through a litigation, a judicial panel. But there is very little recourse for tribes like mine who are not federally acknowledged to have their day in court, so to say.
And why is that? There can't be class actions. Is it just a failure of the courts to recognize your right to represent the class because they don't recognize the nation?
There was a case, Mwekma in San Jose, just in the past 10 years, and all the judicial officer did was refer it back to the executive federal process.
And I take it this is something it would be an understatement to suggest this is frustrating for you. There's got to be some solution to this that's not just simply blocked by bureaucracy.
Well, it's funny you say that. So my tribe's team that's really leading these efforts includes Dr. Champagne, who is a renowned sociologist and American Indian Studies professor from UCLA, and Carol Goldberg, who was vice chancellor and from the School of Law at UCLA. And both of them have a book coming out, which is a socio-political legal analysis of my tribe in particular, and are making the very legal case as to why we need to be federally acknowledged. And I think a lot of that work in combination with the new Truth and Healing Council will lay the groundwork for future reparations and reconciliation for California tribes.
And it's your position that this this should pass through the tribal council, pass through the appointed, as opposed to the appointed representatives, as opposed to being passed out individually. Like my mother got distributed a $1,500 check at one point and a $7,500 check at some other point dealing with slave labor. So you'd rather see it pass through the councils than go directly to individuals, because that decreases the attachment and empowerment of the Native American councils.
When it comes to California nations, the fact that there are about 100 federally recognized tribes and nearly 100 more that are not, I don't think there's going to be a cookie cutter fix in terms of how reparations are going to be distributed. Because some of these tribes, because of centuries of historical trauma, are not as institutionalized or have strong tribal governments the way mine does, or other tribes. So there's going to have to be some type of workaround for those communities who have irreparable harm because of the genocide.
Serena, we've only got about 2 minutes left. I'm wondering if you want to 2 or 3, no, I think 2 minutes left of airtime. You want to take back over? Can I hand it back to you?
Sure, absolutely. Well, I want to thank everybody for being a part of this conversation tonight, and I really appreciate what you lifted up, Stan, which is that the difference of how the United States has been so helpful for some communities that aren't from here, and yet we fail to recognize the genocide of the indigenous people, and that we're sorely in need of recognition of that genocide and reparations and reconciliation. This I think that this was the start of a really incredible panel, and I could imagine having each of you talk for an hour. And so I want to thank you again for sharing such rich and complex issues with us tonight. We at Jewish World Watch, again, we look forward to continuing to partner with you, and this is an ongoing conversation that cannot be done in just one night. And if you want to continue to help us create programming like this, please go to jewishworldwatch.org/impact, participate. We do have one more conversation on Thursday night, which will be a part of, it'll be our last panel in this 4-part coalition series. We'll talk about addressing trauma through comprehensive and holistic means. We hope to have more of these conversations in the weeks and months ahead. So again, please go on jww.org/impact for more information, and feel free to reach out to us if you want to hear more from any one of these panelists. Stan, thank you so much for moderating this panel tonight. Rajika, thank you for everything you did to make this happen. And Pam and Sherry, thank you for all of the information you shared. Have a wonderful evening, everybody.